Hi, everybody. Thanks for joining me here for this discussion on the Family Medical Leave Act of 1993, more commonly known as FMLA. Now, before we begin, I want to make sure we all recognize that we are talking about legislation here which can be updated and changed over time. So, while this discussion incorporates the current legislation as of the time of this recording, depending on when you view this recording, you'll always want to make sure that you do go back and check the most updated laws. So we're going to start here by asking the question, what is FMLA? And FMLA is basically a law that says that employers must provide up to 12 weeks of unpaid leave with benefits for employees under a variety of different circumstances. Okay, and these circumstances include childbirth or pregnancy, adoption or foster care, okay, care for a sick parent, child, or spouse, okay, serious health condition. And when we talk about a sick parent, child, or spouse, we're talking about a serious health condition. In this bullet point here, we're talking about the employee actually having a serious health condition. And finally, a qualifying exigency or an event with an active duty family member. So if a family member is in the military and has a qualifying event, uh, an individual could be eligible for FMLA as well. Okay, so there are certain types of employers who have to comply with FMLA, and then there are some employers who actually aren't responsible for complying with FMLA. We're going to start with government employers. All government employers are responsible for complying with FMLA, no matter what the size of the employer or any of their other characteristics. Similarly, all elementary and secondary schools are responsible for complying with FMLA. And then finally, some private businesses have to comply with FMLA as well. So now we're going to discuss the types of private businesses that have to comply with FMLA. And essentially, we start with private businesses that have 50 or more employees in the location where the employee applying for FMLA works. Okay, so if an employee works at, we'll say, a retail store, and the retail store has 50 or more employees, they are responsible for complying with FMLA. Now, the 50 employee stipulation only falls into place if the employer has at least 50 employees for at least 20 weeks out of the year. Okay, and basically what this means is that companies that have very seasonal businesses where they ramp up their staffing for very short periods of time may not be required to comply with FMLA. So let's say you have a retail store and your busy time comes around the holidays, and you typically have 20 to 30 employees, but in November you hire a lot of temporary workers and you ramp your staff up to about 50. Okay, and you have this staff for 4 weeks in November, 4 weeks in December, and then after that you go back to your normal 20 to 30 employees. In that case, you would only have 50 employees for about 8 weeks. You would not be required to comply with FMLA. And then finally, we start to take a look at where are these 50 employees. So essentially, if a company has 50 employees within 75 miles of the location where the employee seeking FMLA works, they are responsible for complying with FMLA. So in this example, we'll say that the private business has 3 employees in one location. But within that 75-mile radius of that location, they have over 50 employees. Then that location that only has 3 employees still must comply with FMLA. Now, locations that are more than 75 miles from these other businesses are not necessarily required to comply with FMLA. So, for example, if that business has another location that is 150 miles away from the locations on the right, and that location has 48 employees, but there are no other locations around them that have more employees, then this one location over here on the right is not required to comply with FMLA, but this location over here that only has 3 employees is required to comply with FMLA because within their 75-mile radius, the company has 50 employees. Okay, next we're going to talk about eligible employees. And there are a few different things that make employees eligible for FMLA. The first is they have to have 12 months of experience with the company. Now, that experience does not all have to come at the same time. Okay, so if you worked with the company for 6 months and you had a year of experience with the company prior to that 6 months, that can all add up to be your 12 months experience. But time before a 7 year gap doesn't count. So if you took 7 years or more away from the company, any time before that doesn't count towards your 12 months of time with the company. The employee must work 1,250 hours in the 12 months prior to requesting FMLA. Okay, and what that basically means is if they work 12 month in that 12 months, if they work 1,250 hours, that's about an average of 25 hours a week they have to work. Okay, they also have to work in a location that meets the 50 employee requirement that we just discussed. As well as they can't be a key employee. Okay, and key employees are typically defined as being salaried and in the top 10% of pay for employees within the 75-mile radius that we looked at before. So if you were in the top 10% of pay in your location, but not within the 75-mile radius that we looked at, you wouldn't necessarily be classified as a key employee. Now, key employees can request to have time off through FMLA, but they're not guaranteed the ability to return if they do request that. All right, so next we're going to look at some of the key terms here that we want to review. And if we go back to our initial discussion on what is FMLA, we said employers have to provide 12 weeks of unpaid leave with benefits for employees who have to care for a sick parent, child, or spouse. So first, as we go through the key terms, we're going to define what is a parent, okay? And there are several different classifications that fall under the term parent in FMLA. The first one is a biological parent. Okay, then we also have a step parent, or the spouse of your biological parent counts as a parent under FMLA. Okay, an adoptive parent or a foster parent can also count under FMLA. And then we have something called a person who's a parent under loco parentis. Okay, now what exactly does loco parentis mean? To answer this question, we're going to go back to 1994 and a little TV show called Party of Five. And in this TV show, we see Nev Campbell before Scream, Scott Wolf before Nancy Drew, and then over on the right, we've got Matthew Fox before Lost. And in this show, the 5 different people that you're seeing here, they were all siblings, and Matthew Fox played a character named Charlie. Charlie was the oldest of the 5 siblings. And there was a tragedy in the show, and the siblings lost their parents, and Charlie here had to step up and fill the role of being a parent for his 4 siblings. Now, he did not necessarily get legal custody. He wasn't an adoptive parent. He obviously wasn't their biological or step parent, but because he was acting as a parent in this role, he fell under the category of loco parentis. So basically, loco parentis is any situation where an individual is acting as a parent even though they may not have legal standing as a parent. Okay. A parent also does not include a parent in law, and that's an important component to remember here. So, for example, if my wife's mother or father was to get sick and need help with care, I would not qualify for FMLA to care for them because they are my parents in law and they don't fall under the definition of a parent through FMLA. Next key term that we're going to look at here is a spouse. And a spouse is essentially under FMLA a husband or wife. Okay, this does qualify for same-sex marriages, count as husband or wife under FMLA. And we also have common law marriages here. And a common law marriage is a situation where people are acting as a husband and wife. They refer to each other as husband and wife. They sometimes file their taxes in similar ways as spouses do, but they haven't actually gone through the legal process of getting married. Now, the key here to understand is that husband or wife has to be recognized as a spouse based upon laws in the state in which their union took place. The state in which they currently reside is immaterial in this situation. So, for example, if a couple got married in California, but their marriage was not recognized in the state that they live in now, they would still qualify as spouses under FMLA because their marriage was recognized in the state in which the union took place. Okay, another important component that we want to remember here when we look at spouses is that civil unions are not guaranteed coverage under FMLA, but employers absolutely have the right to create and implement policies that allow for a different type of leave coverage for individuals in civil unions. All right. The final key term that we're going to go over here is that of a child. Okay, and a child essentially is going to be a biological step, fostered, adoptive, or loco parentis child based upon the definition that we looked at with a parent. Okay, but there are a couple stipulations here. A child has to be under the age of 18, or the child can be over the age of 18 but not capable of caring for themselves due to a disability. So if a child is in a situation where they become disabled and they're over the age of 18 and their disability prevents them from taking care of themselves, then they still qualify as a child under FMLA. It's very important to note, though, that a disability alone does not qualify one as a child for FMLA. The disability must prevent self-care. So if a person has a physical disability but is perfectly capable of caring for themselves and is over the age of 18, they do not qualify as a child under FMLA. Okay, there's also an active duty provision to FMLA that we should mention here. And basically what the active duty provision says is that FMLA can be extended for up to 26 weeks to care for next of kin family members who need care because of an injury that they received during active duty in the military. So if your family member received an injury while in active duty, then you get more time under FMLA than for other serious medical conditions. Now, one question that often comes up with FMLA is, can employers ask for verification of the need for FMLA? And the answer to that sometimes is yes. And the cases where the answer would be yes would be if a person has a personal serious health condition, or if they're requesting FMLA to take care of a family member with a serious health condition. But there are also times where employers cannot ask for verification for FMLA. And examples of situations where they can ask for verification are in the case of the birth of a child, an adoption, a foster placement, or the need to bond with a new child. And employers have some basic responsibilities under FMLA here that we'll cover. And the first of these basic responsibilities is they have to post an FMLA notice or a fact sheet where employees can see it. And if they don't post this notice or fact sheet, they can be subject to a fine. Okay. They also have to be sure not to impede the use of FMLA. So employers can't create pressure or have policies that prevent employees from using FMLA. This obviously does not necessarily apply to key employees, but for all other employees, they cannot do anything that would impede the use of FMLA. They have to notify an employee if they are eligible for FMLA upon request. And if an employee requests an FMLA leave, they also have to notify the employee if the leave is classified as FMLA. Okay, next they have to continue benefits coverage through an FMLA leave. And finally, they have to restore the employee to their original job or an equivalent job at the same pay and benefits when they return from their leave. Some basic employee responsibilities include providing 30 days notice for a planned leave. So if an employee has a major surgery coming up, but it's a scheduled surgery and they know about this surgery 2 months in advance, they have to let the employer know at least 30 days in advance. They can't just call up their boss 2 days before the surgery and say, hey, I've had this surgery scheduled for 2 months. I need to take an FMLA leave. They have to give 30 days notice if they have the availability to do so. If they don't have the availability to do so, as we sometimes don't in emergency situations, they have to provide as much notice as possible. And then finally, they have to provide verification when the request for verification is legal. Okay, that's an overview of FMLA. For more information on FMLA, you can visit the U.S. Department of Labor's website, particularly the Division of Wage and Hours. Okay, hope you enjoyed this video. Hope you learned something, and we will talk to you soon.